Welcome back to Arkansas, where we try to make sense of the issues affecting Arkansans. And today, we're going to talk about Ballot Issue 3, which will appear on your ballot in November of 2022, under the name the Arkansas Religious Freedom Amendment. Issue 3, like Issues 1 and 2, is a constitutional amendment proposed by the Arkansas legislature and sent to Arkansans to be ratified. Issue 3 can be really confusing, and the only way to understand why it's on the ballot and what it would do is with a bit of history. So let's dive in. The First Amendment to the U.S. Constitution, part of the Bill of Rights, includes the following phrase, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, unquote. These two phrases are usually called the Establishment Clause and the Free Exercise Clause, and historically, the Free Exercise Clause was interpreted to mean that the federal government cannot enact restrictions that target a specific religious practice. However, that does not mean religious practices are exempt from laws that affect everyone else. A law that is not targeted at a specific practice or group of people is called generally applicable, as in it generally applies to everyone. And for about the first 200 years of America's existence, the Supreme Court said that generally applicable laws do not violate the Free Exercise Clause. For example, in the late 1800s, Mormons tried to argue that marrying multiple wives was part of their expression of religion, so they should be exempt from laws restricting marriage to two people. But the Supreme Court ruled against them, reasoning that those marriage laws were generally applicable, and so they didn't violate the Free Expression Clause. But the legal standard began to change around the 1960s. During that time, the Supreme Court made a series of rulings which indicated a shift in how they interpreted the Free Expression Clause. Their new interpretation was that even a generally applicable law might violate the Free Expression Clause. So to make sure that didn't happen, they created a legal test called strict scrutiny. And here's how strict scrutiny works. Let's say you went to court in the 1960s and showed that a generally applicable federal law was keeping you from a practice which was part of your provable religious tradition. If the government thought the law should still apply to you, they'd have to prove two things. First, that the government had a compelling interest in the law applying to everyone. Compelling interest means it's important to the function of the state or country that the law is followed by everyone. So laws about the military, national security, public safety, and health are usually considered compelling interests. Second, even if the government could prove a compelling interest, the law had to be the least restrictive law possible which would achieve that compelling interest. If the government could not prove those two things, then you would be granted an exemption from the generally applicable law. Either the law stays but can't be applied to your religious practice, or the law gets struck down entirely. Two big examples of this. In one case, the court ruled that South Carolina had to pay unemployment benefits to a worker who had been fired because his religious practice kept him from working on Saturdays. In another case, the state of Wisconsin was told it couldn't require Amish children to attend school after 8th grade because the Old Order Amish Church believes exposure to the worldly influence and competitive nature of high school is a literal danger to their children's salvation. This new strict scrutiny test was seen as the standard in the 1960s and 70s, opening the door for more religious exemptions to generally applicable laws. But then in the 80s and 90s, the court began to shift back towards the general applicability standard, making it harder for religions to carve out exemptions. That change did not go over well with the general public, and one case in particular got folks really riled up. It involved two Native Americans who had taken the drug peyote during a religious ceremony, which caused them to later fail a drug test at work and get fired. The state of Oregon refused to grant them unemployment benefits because the laws against using peyote were generally applicable, and the Supreme Court agreed. The case garnered a lot of public outrage, even among groups who were usually on opposite sides of the issues. And as a result, in 1993, Congress passed the bipartisan Religious Freedom Restoration Act, or RFRA. That act says, in part, quote, government shall not substantially burden a person's exercise of religion, even if the burden results from a rule of general applicability, unquote. And the only exception is the old strict scrutiny test. The burden has to be for a compelling government interest, and has to be the least restrictive way the government can meet that interest. RFRA initially applied to federal, state, and local laws, but in 1997, the Supreme Court ruled that RFRA could only apply to federal laws, reasoning that the federal government should only be able to make exceptions for laws it had passed in the first place. So if states wanted similar protections, they'd have to pass them at a state level. 19 states passed state-level RFRA laws in the years that followed. But then, in 2010, Congress passed the Affordable Care Act, also known as Obamacare, which included the requirement that employer-provided health care plans in the U.S. have to pay for certain medicines, including birth control. Now, churches and religious organizations were exempted from that requirement from the beginning, but some companies run by religious people thought they should be exempt too, including Hobby Lobby. Hobby Lobby filed a lawsuit, and in 2014, the Supreme Court ruled that corporations owned by a small group of people tied to a specific religion could claim exemptions under RFRA. Some states saw that ruling as a signal that the Supreme Court was open to larger religious exemptions, particularly for religious businesses. And this happened around the same time it became clear the Supreme Court was about to overturn state laws against gay marriage. In response, both Arkansas and Indiana proposed their own versions of RFRA in 2015. But both bills also included some brand new language intended to enable businesses to refuse to serve customers if the businesses believed serving those customers violated their religious practices. Indiana's bill was met with a huge backlash, including protests, boycotts, and canceled events. And that backlash also brought negative attention to Arkansas's bill, including a very public pushback from Axiom and Walmart.
Today's passage of HB 1228 threatening to undermine the spirit of inclusion present throughout the state of Arkansas. We are asking Governor Hutchinson to veto this legislation. In turn, Governor Hutchinson sent the original bill back to the legislature, who rewrote it to be a much closer copy of the original RFRA. In April of 2015, that bill became state law as Arkansas Act 975, and it's still the law today. That seemed like the end of things, but then COVID happened. In 2020, during the COVID pandemic, Governor Hutchinson, along with the Arkansas Department of Health, enacted a number of executive orders designed to minimize COVID transmission. Now, Arkansas never ordered places of worship to close and never issued enforceable mandates to churches, just guidelines, suggestions including social distancing, providing hand sanitizer, and requiring face coverings. Those guidelines were also not enforced in any way other than issuing warnings, but some Arkansas legislators still thought they went too far, or were worried that in a future emergency they might become mandates. So, when the legislature met for their first session after those COVID guidelines were issued, they passed a bill which created explicit exemptions for religious organizations during emergencies. It also included some language aimed at the governor, which should sound pretty familiar by now. Quote, "The governor shall not enforce a health, safety, or occupancy requirement that imposes a substantial burden on a religious organization unless the governor demonstrates that applying the requirement to the religious organization is essential to further a compelling governmental interest and is the least restrictive means of furthering the compelling governmental interest." Unquote. But the legislature was not satisfied with just changing the state statutes. They wanted to put the RFRA language into the Arkansas Constitution. So, during that same legislative session, they wrote Issue 3 and sent it to our ballots. So now that you have that history in mind, here's what Issue 3 actually says. Issue 3 would amend the state constitution to include a version of the language from RFRA. Specifically, it says, quote, "Government shall not burden a person's freedom of religion, even if the burden results from a rule of general applicability." Unquote. Government here refers to Arkansas government at all levels: state, county, municipality, townships, etc. The amendment then sets up which generally applicable laws could still apply by using the strict scrutiny test. The state of Arkansas would have to show that the law is a compelling government interest and is the least restrictive law possible to further that interest. Issue 3 specifies that it would apply to every Arkansas law, regardless of when it went into effect or if its statute
statutory. That means that this amendment would apply not just to written laws, but also to official actions and decisions made by Arkansas officials. And anyone whose religious practice had been illegally burdened could use this new amendment as a defense of their actions in court, or could proactively make a claim against the government for relief. Issue 3 doesn't clarify if that relief just means an exemption from the law, or if it could also mean compensation of some kind. The first few sections of Issue 3 are copied from RFRA almost word for word, just swapping out things like the United States and Arkansas. Plus one other change we'll talk about shortly. But after all of that homework copying, Section 6 of Issue 3 isn't from RFRA or Arkansas Act 975 at all. Section 6 has two parts, and the first is complicated. It says, quote, "This amendment shall be liberally construed to effectuate its remedial and deterrent purposes," unquote. That is a complex sentence, and its wording seems different from the rest of Issue 3. And that's because it is. The phrase has been added to many different laws in U.S. history, perhaps most famously the Racketeering Act of 1970, better known as RICO. Because the definition of racketeering is a bit vague, basically coordinated crime, the clause is meant to encourage courts when they're unsure to assume a case does fall under that category. So, this sentence means that when Arkansas courts are trying to decide if someone should be granted a religious exemption, if they're unsure, they should default to granting that exemption. Finally, Section 6 ends by saying that courts cannot invalidate this whole amendment by invalidating just one part of it. And now we need to talk about a single word: substantial. The original federal RFRA says, in part, quote, "Government shall not substantially burden a person's exercise of religion," unquote. Arkansas Act 975 says, quote, "A government shall not substantially burden a person's exercise of religion," unquote. But Issue 3 drops the word substantially. Because so much of the other language in Issue 3 was copied directly from those earlier laws, any change must have been made on purpose. So why change that one word? Well, in the past, some federal cases trying to claim exemptions under RFRA have failed because the courts found that, while the government may have been burdening someone's exercise of religion, it wasn't a substantial burden. For example, in Navajo Nation versus U.S. Forest Service, the Forest Service was running a ski recreation area on a peak in Arizona and began using artificial snow machines which ran on recycled wastewater. The local Navajo people, who believed the whole mountain was sacred and regularly held religious ceremonies there, filed suit under RFRA, claiming that use of recycled wastewater profaned their sacred site. But the court ruled that it wasn't a substantial burden because it didn't force the Navajo to stop their religious practices or act in a way that violated their beliefs. To put it another way, a substantial burden is forcing someone to change their religious practice. A burden just means inconveniencing them. So, removing the word substantial would make it easier to claim an exemption under the rules of Issue 3. Of the states that have their own RFRA laws, most use the phrase "shall not substantially burden." Missouri, New Mexico, and Rhode Island instead just say "shall not restrict." Meanwhile, just 2 states only say "burden." Connecticut, where their RFRA language is regular state law, and Alabama, the only state so far to put RFRA language into their constitution. In fact, Alabama's RFRA law is a constitutional amendment, drops the word substantial, and includes the liberally construed clause, making it a near identical copy of Issue 3. And those changes have had real consequences. Back in 2015, a group of Buddhists who ran a meditation center in Mobile wanted to expand and move to a quieter area. So they bought some land in a residential area and then asked the city planning board for approval. But they were rejected. The Buddhists took the city to court, claiming that rejecting their application and forcing them to find a different location was a burden. And in 2020, the court ruled in their favor, saying that dropping the word substantial meant that Alabama had to defer to religions more than the federal government does. Quote, "Given the post-RFRA context in which the Alabama Religious Freedom Amendment was adopted, and its pointed rejection of the phrase substantially burden in favor of burden simpliciter, we conclude that qualifier's omission was intentional. What the amendment says is that any burden, even an incidental or insubstantial one, suffices to trigger strict scrutiny," unquote. Given that Issue 3 and Alabama's amendment make the exact same changes from the original RFRA, and both are constitutional amendments, it's reasonable to assume that if Issue 3 passes, the state of Arkansas would also have to defer to religious exemptions more than the federal government does. So now you know what Issue 3 says and means. But before we move on to the arguments for and against Issue 3, let's clarify something. The vast majority of what Issue 3 says is the same RFRA language already in Arkansas Act 975, which is currently state law. If Issue 3 passes, that language becomes part of the state constitution, which rules over all the other state laws. But even if Issue 3 fails, the language it shares with Act 975 will still be regular state law. That would not go away. So we're not going to spend much time on arguments for or against the parts of Issue 3 that will still be state law no matter whether it passes. Instead, we're going to focus on two questions. First, are you for or against the existing law being elevated to the state constitution? And second, are you for or against the changes between the existing law and Issue 3? With that in mind, here are some arguments for and against Issue 3. One argument in favor of Issue 3 is that elevating RFRA's language to the state constitution would keep it from being too easy to change or invalidate. Right now, Act 975 is just a regular state statute, at the same level of legal importance as every other state statute. So, if there was a legal challenge claiming that Act 975 contradicted another state law, the courts would have to decide which one to uphold, weighing them about equally. It also means that right now Act 975 could be invalidated in state court or changed in the legislature by a simple majority vote. But if Issue 3 passes, Act 975's exemptions become part of the state constitution, meaning that they override any Arkansas laws that are not part of the Constitution. And that includes, for example, laws defining what powers the governor has during an emergency. So during future emergencies, governors couldn't place restrictions on religious practices that didn't pass the strict scrutiny test. Putting that RFRA language into the state constitution also would mean that legislators could only change them in the future through another constitutional amendment. Proponents of Issue 3 argue that these religious exemptions are too important to leave up to the whims of legislators or judges, and that's why they need to be part of the state constitution. Another argument in favor of Issue 3 centers around the change from may not substantially burden to may not burden and the inclusion of the liberally construed clause. Those changes mean that the Arkansas protections against burdens would be stronger than the federal ones. For an idea of how this might apply, let's look back at the COVID pandemic. The emergency guidelines in Arkansas ask that places of worship provide hand sanitizer, require masks, and practice social distancing. The state also published a map of contact traced infections at churches, which some churches argued scared congregation members away. Are those substantial burdens on religious practice? Maybe, maybe not. But they definitely are a burden. And even if they aren't laws, Issue 3 covers all official actions by state employees. So, thanks to its changes from Act 975, Issue 3 could make it even harder for Arkansas state officials to successfully enact any restrictions on religious practices, even in emergency situations. Proponents of Issue 3 might argue this is a good thing, because the whole point of RFRA-style laws is to limit government overreach. And here's a final argument for Issue 3. Part of why organizations like the ACLU supported the original RFRA was because it offered protections to religious groups who are traditionally marginalized. In fact, in its first 3 years as law, 18% of RFRA cases involved Jews, Muslims, and Native Americans, despite those groups only accounting for about 3% of the population. Thanks to the example of Alabama's RFRA, it's clear that dropping the word substantial and including the liberally construed clause will increase how many cases Issue 3 applies to. And that could increase the power of smaller religious groups to fight laws or government actions pushed by more popular religions. In the Alabama Buddhist Meditation Center case, there was a a very vocal group of Christians who spoke out at the city zoning meetings saying they didn't want a Buddhist center in their backyard because that religion didn't fit in with their neighborhood. But dropping the word substantial from Alabama's RFRA is exactly what allowed something as simple as that permit rejection to be viewed as an illegal burden on the Buddhists. And the same thing could happen in Arkansas. For example, in 2017, Arkansas erected a Ten Commandments monument on the state capitol grounds. The state said they would allow other donated religious monuments on the grounds too, but each one needs a bill of sponsorship passed by the legislature. That provision was used to block the installation of a donated statue of Baphomet by the Satanic Temple. But if Issue 3 passes, the Satanic Temple may be able to argue that the requirement for legislative sponsorship creates a burden. Not a substantial one, but a burden for certain. Some proponents of Issue 3 argue that protecting marginalized religions like that is what RFRA-style laws are made for, and the changes between Act 975 and Issue 3 would make it apply in more situations and help it achieve that goal. So, if you like our existing Arkansas laws about religious exercise being exempt from some state rules, and you want those exemptions to become part of the state constitution, or if you want the exercise of religion to be exempted from even more state laws, including laws that create any burden at all, then you'll want to vote for Issue 3. So now, let's look at the arguments against Issue 3. Some folks against Issue 3 say that making the state's existing RFRA law harder to change is a bad idea. In most states that have passed RFRA-style laws, they remain regular state statutes, which allows them to be updated later by passing another regular law, and that can be useful. For example, when Indiana passed its RFRA-style bill, it got backlash from folks who thought the bill would allow religious businesses to discriminate against LGBTQ people. The Indiana legislature acted quickly, passing an update to the law just weeks after the original bill passed. That update clarified that Indiana businesses could not claim a RFRA exemption to deny services, facilities, employment, or housing to someone. And other states have added similar language to their RFRA laws. But Issue 3 doesn't include those protections, and elevating the language from a regular law to the Arkansas Constitution would make it harder to add them in later, or to fix any other issues that arise. Some opponents of Issue 3 think that's a bad idea. Another argument against the language of Issue 3 is that it doesn't define what it means by person, and it really needs to. Now, the original RFRA language didn't specifically define that either, nor did many of the states that passed RFRA laws before the Hobby Lobby decision. But the Hobby Lobby decision specifically came about because the Supreme Court looked at the federal RFRA language and decided the word person should be interpreted to include certain corporations. Since then, many states with existing RFRA laws have updated them to include a definition of person. Some include corporations, some don't. And 2 of the 3 states that proposed RFRA bills after that decision included a definition as well. But Arkansas Act 975 did not. And neither does Issue 3. What Issue 3 does include is that Section 6 bit, which says the amendment should be liberally construed. Taken together, this means Issue 3 leaves its definition of a person up to the courts, along with an instruction to interpret that definition as loosely as they like. For folks who either don't want religious exemptions extended to corporations, or just don't like ambiguity, the lack of a definition of person could be a reason to vote against Issue 3. The timing of Issue 3 also seems to come in response to the governor's actions during the COVID pandemic. If Issue 3 passes, it could serve as a constitutional reinforcement to the new law which limits the restrictions state officials can place on religious organizations during an emergency. But some folks against Issue 3 thought the Arkansas COVID guidelines for places of worship were not enough and should have been upgraded to enforceable mandates. And in turn, those folks don't want to pass an amendment which would make it easier to get a religious exemption for behavior that may place a community or the entire state at greater risk. A final argument against Issue 3 is that the wording changed from may not substantially burden to may not burden, and the language encouraging the amendment to be liberally construed could make getting a religious exemption too easy. While this may seem like a slippery slope argument, keep in mind the wide range of practices which are currently protected under the federal RFRA laws. Practitioners of Santeria are allowed to engage in animal sacrifice rituals. Certain Native American groups are allowed to use the hallucinogen peyote during religious ceremonies. And religious businesses like Hobby Lobby are exempt from federal requirements for employee insurance coverage of birth control. There are also RFRA claims in court right now from a Hasidic Jewish community who believe their children should not be held to state or federal education standards, and from the Temple of Satan, who argue that abortions are part of a religious ritual for them, so they should be exempt from state abortion laws. All of those exemptions were made or are being argued under laws that require a person or group to prove a substantial burden. Lowering the requirement to a burden of any kind, and including the liberally construed clause, means a wider range of practices will be protected under Issue 3. In fact, the judges in the Alabama Buddhist Center case said that their state using burden instead of substantial burden was likely to open the floodgates to all kinds of exemption claims. As a near carbon copy of that Alabama law, Issue 3 would presumably do the same. Some folks oppose Issue 3 because they believe the religious practice protections Arkansas already has in place are either sufficient or too much, and either way, they should not be expanded by softening their language. So, if you don't want a version of the existing Arkansas RFRA law to become part of the state constitution, for any number of reasons, or if you think weakening the power of the state to impose restrictions during emergencies is a bad idea, or if you think the changes introduced by dropping the word substantial and adding the liberally construed clause might make it apply to too many situations, then you'll want to vote against Issue 3. And that's it. Thanks so much for watching. If you enjoyed this video, you can subscribe and join us on more explorations of Arkansas politics and history. You can also check out our other videos on voter issues this year. And if you want to help us create more videos like this, consider donating to Arkansans on Patreon. Patreon is the easiest way to support content makers in a way that works for your budget. You decide how much you want to give each month, and you can change that amount at any time. And bigger donations get bigger perks, including a sneak peek at our upcoming documentary about the myths and truths around the reputation of Harrison, Arkansas. And speaking of our patrons, thanks to Zach Green, Tim in Vegas, Alan Archer, Blake Hulse, Jordan Little, Madeline Applegate Gross, and Poetize with Deanna Starshine for making this video happen. Thanks again, and see you next time for more Arkansans.